Hello, my name is Jeff Moats, and I'll be presenting a case on Lee versus Yellow Cab for Dr. Debbie Smith's Legal Environment of Business. This is a pretty incredible case when you think about how a simple car accident in Los Angeles can forever change the way a judicial system looks at negligence and really all of the consequences of that negligence for potentially millions of people. The case title and its citation is Lee versus Yellow Cab, found in Volume 13 of the California Reporter, starting at page 804, and it was decided in 1975. The facts of this case are as follows. At the time that Na Lee, the plaintiff, stopped about 70 feet from the 3rd Street intersection and proceeded to cross 3 lanes to turn left, intending to enter the driveway of a service station, a Mr. Robert Phillips, an employee of the defendant, Yellow Cab Company of California, passed through the same intersection at approximately 30 miles per hour while the light was yellow. This resulted in a collision. The determination was that the defendant was traveling at a speed that was unsafe at that time and place. It also found that, quote, the plaintiff's left turn across the southbound lanes was made at the time when a vehicle was approaching from the opposite direction so close as to constitute an immediate hazard, unquote. What that basically meant was that the plaintiff should have seen the hazard and not made the left turn. The trial court found that Na Lee was negligent in making the left turn and that the negligence was a proximate cause of the collision. Therefore, a judgment was entered barring her from collecting damages by reason of her contributory negligence. Now, I'll spend a minute just defining contributory negligence. It's a doctrine that basically bars the plaintiff from any form of recovery if the plaintiff's own fault contributed to the injury. Doesn't matter how small a degree or how slight. An alternate doctrine of assessing negligence is comparative negligence. These two competing doctrines bring us to the case's main issue. That main issue is, should the doctrine of contributory negligence give way to a system of comparative negligence? Now, this case was heard by the Supreme Court of California, where the justices basically answered yes to the previous question and overturned the trial court's decision, thereby setting a major precedent in California state law. Essentially, they were choosing the doctrine of comparative negligence over contributory negligence. They held that from a logical, practical, and fundamental justice perspective, that the doctrine of comparative negligence is preferred over contributory negligence. The Supreme Court was concerned with a few other things, namely overstepping their bounds on statutory construction, unforeseen future issues, misinterpretation of the doctrine of comparative negligence and its applicability, and finally, whether or not it should be retrospective as well as prospective. In consideration of these things, it held that Section 1714 of the Civil Code, which many believed codified the contributory negligence doctrine, was not mutually exclusive of the decision they were making. Some may say this is sort of like talking out of both sides of your mouth. With one breath, you're saying we're going to consider future cases using this new doctrine, and with another breath, you're saying that the previous doctrine will still exist in the Civil Code, but we'll probably just never use it. In reference to the unforeseen future issues, it held that these practical difficulties should really not withhold or dissuade charting a new course. And they basically said that they'd take it one step at a time and use future judicial and legislative action to resolve any future problems. They were also very clear on using the pure form of comparative negligence, where liability is in proportion to the fault, regardless if the plaintiff is more or less at fault than the defendant. And they also held the doctrine would only apply prospectively, but only in limited circumstances retrospectively. Now, the rationale behind all of these holdings was really twofold. The first was an attack on contributory negligence, calling it inequitable and unable to distribute responsibility according to fault. The other rationale was the praise of comparative negligence and how fair and logical it is to assess liability according to fault. Now, no matter how many times I read this rationale, all I could think about was two kids fighting with each other, yelling, it's your fault, and somehow imagining the mother stepping in to determine exactly how much fault would be placed on the kids. They also noted two other reasons which seemed a little less valid. The first was sort of an ends justifies the means argument by explaining how juries were already compromising, regardless of the doctrine of contributory negligence, by favoring the plaintiffs, even if they were partially at fault. And the second was a sort of bandwagon argument of the fact that 25 other states had already subscribed to the same doctrine. Now, at the end of this case, there were two opinions that really stuck out. One was a concurring opinion by Mosk that sort of seemed like a dissenting opinion if it weren't for the first sentence. He basically agreed with the majority opinion, but disagreed and even somewhat took offense to only applying the rule prospectively. He offered a third option of at least applying the new doctrine to the case at hand, meaning the case that brought the issue to the judicial attention. But in the end, the majority opinion was only in favor of prospectively applying it. The second opinion, which was dissenting, was by Clark. Clark's comments were from the standpoint of the earlier concern of the judiciary overstepping their bounds and moving into a statutory construction role, which we all know is a role reserved for the legislature. He was essentially disagreeing that the Supreme Court should have selected the comparative negligence doctrine, since there are so many other negligence assessing doctrines out there. Just because they viewed the contributory doctrine to be insufficient didn't mean the comparative doctrine was the right way to go. Nor did he believe the judiciary was equipped to make these types of determinations with their limited resources. Overall, his dissenting opinion was written to the California Register, but did very little, if anything, to curb the obvious judicial activism in this case. This was the case briefing for Lee versus Yellow Cab. Thank you.